Well, Shock, real quick, before you guys get started, I'm sorry for interrupting. Can you check your microphone and just change it to microphone array, Realtek, or audio?
Got it. Let me move this real quick.
I just put us on the record, but
Sometimes you're super crystal clear and sometimes you're not, so.
Uh,
All right. If you guys are ready.
thank you, Ms. Cannington. We're on the record. It is May 20th, 2025, Tuesday at 9:30 a.m. And this is a deliberation of the Board of Appeals of Baltimore County in the matter of Flagship Maryland Propco LLC for the property at 1630 East Joppa Road in case number 24-123 SPH and 23-229 SPH. I'm Deborah Dopkin, and with me are Fred Lauer and Bill Parshock, my fellow board members. This was an appeal of an order, opinion and order of the administrative law judge for a petition for special hearing. The order was dated September 24th, 2024. Case 23-229 SPH has been withdrawn by the petitioner, but in case number 24-123 SPH, the petitioner requested a determination of the date of the final order for purposes of Baltimore County Zoning Regulations 502.3 for the original underlying special exception in case number 21-199X, which was dated November 2nd, 2021, and was found to expire on November 2nd, 2023, and further requesting a determination that the special exception granted in case 21-199X was utilized in accordance with the zoning regulation section 502.3 within a period of 2 years from the date of the final order issued in that case. And the ALJ found the special exception was utilized, is not void, and may continue to be utilized through and including the maximum period specified in BCCR 502.3. Now, the issues before us are fairly narrow. The appellant who filed an appeal of the ALJ's decision, which the Loch Raven Village Association, and at the time of the hearing before the Board of Appeals, which occurred on April 17th, that association had not filed and did not have with them the documents required under the board's Rule 8. And the petitioner ruled to move to dismiss. We took the matter, held the matter under consideration. So that is the first issue before us. The second issue involves the date of the final order. The petitioner maintains that it was not November 2nd, but December 2nd, once the order became non-appealable. And then the third issue is whether the special exception was utilized prior to the expiration of the original order in case 2021-199X. Can we first deal with the Rule 8 issue? Mr. Lauer, I'm going to ask for your thoughts on this.
Sure. I think the rule is pretty clear. I don't see any vagueness in the rule. I think the word shall's in there a couple times. And I don't think we have any discretion here, really. I think that under Rule 8, I think there are three steps, I believe, in terms of a resolution and designation of the person and position of the association. And we didn't get any of that. And I don't see any alternative but to dismiss the appeal based on Rule 8 and how we interpret and apply it. Pretty straightforward to me.
And I think that petitioner in its memo pointed out that under the rules of construction articulated in the Baltimore County Code, shall was specifically interpreted to be mandatory.
Yes.
Mr. Polshak.
I feel the same way. There's three guidelines of it. And you know, there is some commencements in cases where we still hear the petitioner, but none of the paperwork was submitted. So I agree.
And I want to say this rule, two things. This rule was adopted to protect members of a community where one person would come forward as alleging they represented a larger group. It really protects the integrity of the association. I also note that this association had in the past complied with this rule, as came up at the hearing. And I believe they have a certain responsibility to maintain their correct mailing information with the planning office and to follow the procedure. And I know that Mr. Mulder complained that the petitioner was not held to such a standard, but it has been a long-standing rule at the zoning office and before the ALJ that any corporate entity has to be represented by counsel. And that is a far more onerous and expensive requirement than keeping your records up to date and complying with this rule. And it's, I don't think, a burdensome rule.
I agree. And the other thing I would point out is that this rule doesn't prevent individuals from testifying, individuals from being proper appellants in a matter, but not the association unless you have the papers. And I think that in what Mr. Mulder's statement, he made some comment about that. And I just wanted to clarify that this really doesn't stop people from appealing themselves if they were parties below and is registered as such. But this was an appeal on behalf of the association. and that's what distinguishes it, and nor other members from testifying. So I just wanted to kind of clarify that point as I see it with the board.
And I also want to point out that under the Crown development case, which was brought by Mr. Zimmerman as People's Counsel, there are broad rules of standing so that if there is only one legitimate appellant, be it an individual, a property owner, a properly represented association, then other parties can come in and join in the as valid parties. But we had no individual appellants in this case. So I would agree with you both that it is appropriate for us to dismiss the case. Now, we have no obligation to go further to discuss the issues on the merits. Do you feel any reason to talk about whether the special what the date was and whether the special exception was utilized?
If the chair would like to, I would be happy to state my position on the matter. I think it might provide guidance in terms of maybe some future action, but you know, I would totally rely on what you think, Madam Chair.
I think that because we are seeing some of these cases pop up on special exceptions, it is worthy of a brief discussion, though it is not the basis on which we will decide the case. That would be on the motion to dismiss. So yes, Mr. Lauer, I would like just 2 sentences on each issue. If
Okay,
that's not-
you want me to go first then?
I do.
You count the sentences, okay? I believe the date should be 30 days after the order was issued,
You believe the December date.
the December 2nd date. As someone who used to count down both ways, as you know, whether to file an appeal or to have an appeal filed against you, I know that I would never advise my client to proceed unless those 30 days had gone, usually including a mailbox rule of another 3 days. So that's my one sentence or what, 2 sentences, whatever. And I do think also that the special exception was utilized. Utilized to me means moving forward, getting permits, doing preliminary grading, things like that. It doesn't necessarily mean you're putting concrete in the ground. I also think that legislatively, someone should look at that 2-year time limit and see, and the review process afterwards. No offense to People's Counsel, but People's Counsel coming out of the blue kind of after this is, you know, it's been approved. I would be pretty upset if I were counsel or the party in the case. So I do think someone legislatively should look at that 2-year limit, because it's come up in other cases recently that I've dealt with. So those are my more than 2, I'm sorry, sentences.
Oh,
Um,
I'm gonna coattail onto Mr. Lauer for 2 things. I'm not sure I agree about the date, though I do agree with the advice you give to clients, because that 30-day is an at-risk period and does not have finality. But the utilization I agree with entirely. And I think we have to distinguish between what utilization is and what vesting is. All the arguments that Mr. Mulder made would seem to be vesting arguments. The utilization to me is sort of a but-for argument. They would not have done X, except to be able to utilize the special exception. And that is all the steps up to and including funding their utility agreement that would not have occurred but for the intent utilizing the special exception. And the third thing having to do with legislation. Mr. Zimmerman was a zealous people's counsel, but I went through the zoning regulations in detail to see where and where a hearing is required, and if there is no mention of a hearing required. And I do not think that extending a special exception was ever drafted and intended to require a second hearing of any sort, either as to the reasonableness of the extension or as to the underlying grant. And that is something, if it's going to change, has to be done by the council, not by us. We don't have the authority.
I agree.
But it wasn't before us, and we're not deciding based on that. But we've had a proliferation of cases and resources being expended, and I hope that we don't see any more of these. Mr. Polshak, I cut you off.
No, you didn't, you never cut me off, but Madam Chair, I do agree with the utilization. It is started just like Mr. Lauer explained it. But the date of the final order is a matter of legal, interpretation of it. And I believe it doesn't become final until the completion of the proceedings. And that would have been, on this case, would have been 12/2 on that date.
December.
Yes.
Well, I'm glad we're not deciding that issue today. Okay, I think that we are in agreement that we are going to dismiss this case. And because of the failure of the association to comply with Rule 8 and there being no valid appellant in these proceedings, whether by an individual or an organization, and that we'll produce a written order and get it out to the parties promptly. And I'm going to go off the record and conclude this deliberation and ask Ms. Cannington to stay on board with us.
Thank you, Madam Chair.
Thank you.